This video, I'm going to talk a little bit about self-defenses to criminal acts because the criminal acts themselves, most of us are fairly familiar with. The defenses, sometimes not as much. So I'm going to talk a little bit about those, and then we're also going to talk about some of the constitutional issues tied to criminal acts. So self-defense, or justifiable use of force, we have to understand what is allowed, what is excessive, what is how does this work? And before we get into the self-defense defense, we're going to talk about these defenses as a whole, because what they're called is affirmative defenses. And with defense lawyers, with prosecutors, with the criminal system, this is a very dicey proposition, I guess is the best way for me to say it, because in order to plead any of these defenses, and I'll list them off real quick: justifiable use of force, necessity, insanity, duress, entrapment, any of these defenses, you have to admit to the commission of the crime. So your first step is taking the prosecutor's job completely away from them. You're saying, yes, I did what you're accusing me of doing. However, I did it because of this reason. And then the trial hedges 100% on whether or not the jury or judge believe you did it with justifiable use of force. You did it due to insanity, due to duress, due to entrapment. And that becomes the issue. And if you are unable to prove self-defense, or you are unable to prove duress, then the job is done for the prosecutor, because you have admitted to committing the crime, and they are allowed to seek sentencing for whatever punishment is the crime you have committed. So when you use these defenses, you have to understand you're walking on a high wire. And criminal cases, really any case, when you get in front of a judge, when you get in front of a jury, you are putting your life, and I'll say more so criminal cases than civil cases, because you don't go to jail in civil cases, but in criminal cases, you're putting your freedom in the hands of one judge or 6 or 12 jurors that are just allowed to hear the evidence that is allowed to be entered into this case. It may or may not be the entire story. There is so much at risk with this, and you have to be very careful. And when you are using these affirmative defenses, you're just raising that level of risk to a whole new level. So self-defense or justifiable use of force, the wording behind this defense is in fear for your life, is where you can use lethal force in self-defense. If you were afraid someone was going to take your life from you, you may use lethal force in response, is the most basic and simple explanation of that. In other aspects of self-defense, justifiable use of force, it is supposed to be force that is equal, commensurate with the force being shown towards you. For example, if somebody threw a water balloon at you that happened to have a marble or two in it, and sure, when it hit you and it broke, it hurt, and they were attacking you with this water balloon, and you may see they have more water balloons ready to throw at you, it would not be appropriate to pull a gun out of your pocket and shoot this person. That's not commensurate. Now, in Arizona, like some other states like Florida, we have certain expansions of this self-defense rule this justifiable force rule to give additional protections in most cases to the person seeking self-defense. You do not have to try and flee first. You are allowed to stand your ground. Um, if you are in your home, on your property, you are allowed to protect your property. You do not have to try and run away from your property. You can stay there. Now, the interesting thing is, if the person who is attacking you or trying to break into your house while you're in your house, you yell at them and you say, "I've got a gun." If they turn around and run away from you and they are leaving the scene, leaving your property, and you are safe because they are running away, you cannot still shoot them or do something else with a bow and arrow or whatever it may be, you throwing a rock. You can't do that because that fear for your life, while you still may feel amped up, feel like the adrenaline flowing, your safety is no longer in jeopardy if they are running away from you. So you have to be very, very careful. And if you want to do a little research and see a very interesting justifiable use of force case in Arizona, if you Google NAU shooter self-defense, college freshman, I believe, and I'll put it in the announcements, the actual case name for you because I don't have it ready. I just thought of it while we were talking. But this was a case where a college freshman was got into a fight with some other fraternity members from a different fraternity. He went to his car to get his gun, came back to the fight, ending up discharging his weapon, and he claimed self-defense, and the prosecutor obviously did not believe it's self-defense. I'm not going to tell you more about the case now because I want you to look it up and read it a little bit, but there will be a link in a discussion for you. So I'll put it there. Now, another big defense that's out there is duress. That, I was under duress. I committed the crime because I had to commit the crime. And in our justice system, there are valid reasons for duress. Someone could be holding a loved one hostage. Someone could be threatening the safety of a building. I am going to bomb a building if you do not commit this crime on my behalf or for me. Now, the one thing I want to share with you, just because I'm a dog lover and I want to share it with you, if someone were to be holding my dog hostage and saying, "I'll harm your dog if you don't do crime A," there's a very good chance I would commit that crime to save my dog's life. Now, the troubling part of this is that if I went to the courthouse and I said to the prosecutor, I was under duress because I felt my dog was going to be harmed if I didn't do crime A, the prosecutor would laugh and say, "I'm sorry, that's not duress." In our legal system, especially in Arizona, dogs are considered property, and therefore you cannot be under duress trying to save a piece of property. So keep that in mind. I want to real quick go and jump to the Miranda rule, which I am guessing you all have read at some point, sometime in a movie or TV show or somewhere, that you have the right to remain silent, you have the right to an attorney. If you can't afford an attorney, excuse me, I'm going to start all over. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney will be assigned to you. And then they ask you if you understand these rights. Now, these rights are something that go all the way back to our Constitution to our Bill of Rights, our Fifth Amendment against self-incrimination, which is the right to remain silent, our Sixth Amendment that says we have the right to counsel. However, not everybody knows these are our rights. And we need to make sure people know that these are their rights. There was a case, the Miranda case, Miranda versus Arizona, that is the basis for the Miranda rule, in which a person, Mr. Miranda, was accused of a crime. He was arrested. He was brought into the police station. He was put into an interrogation room to be questioned, and he was not notified of his rights. He was not aware that he had the right to obtain legal counsel. He was not aware of his right to remain silent. He was not aware of his right against self-incrimination. He spent hours in this interrogation room with one single detective. No tape recordings were made, and he eventually confessed to a crime. And with that confession, he was convicted of that crime, and he went to prison. An organization read about his case, realized he was not aware of his rights, and appealed all the way to the United States Supreme Court to say, because he did not know his rights, his confession should not have been allowed in the trial. And the US Supreme Court agreed. And the US Supreme Court, after this case, drafted what became the Miranda rule of what a police officer would have to say to a client. Not to a client, to a suspect when they were being detained for questioning, when they were being arrested. Interesting side note of this, I guess, the issue was never whether or not Mr. Miranda actually committed the crime. He did commit the crime, and that was never the question upon appeal. It was strictly the manner in which the confession was gained. And if without the confession, could they have obtained a guilty verdict? So those are interesting things that happen. And I will also tell you, with the Miranda rule, and this happens around the country, I know it happens here in Arizona, that police cars are set with recording devices. And oftentimes in the past, police officers, when they handcuff somebody, when they were questioning multiple people, they would handcuff somebody, they would set them on the curb, on the grass, somewhere on the outside. Recently, in the last 3 to 5 years, police officers have come up with a new tactic, in which instead of setting you down on the curb, on the grass, they will set you in the back of the police car. Because in many cases, people who are being detained and ready to be questioned will talk a lot in the back of a police car, and they will be upset that so-and-so got them involved with this criminal activity. They may be mad at the person, may put 2 people in the police car, and they're arguing at each other about what someone did wrong as to why they got caught committing this crime. And all of that evidence, all of that discussion that's recorded inside the police car, that's all admissible, even if they haven't been read their Miranda rule yet, Miranda rights yet, because it isn't the police officer asking questions of the arrested person. It is simply that person talking on tape. And you have to be aware. So my public service announcement for this video, and we'll end at this point, is if for some reason you ever get put in the back of the police car, or any friends of yours ever get put in the back of the police car, do not say anything, because they're recording everything that is said in there. All right, we're going to do one more video on this that's going to go in very briefly into cybercrime, and then that will be chapter 7 in a nutshell for you.